Right now, I want to turn to our top story for you this morning, and that is the closing arguments in Mama Donna's murder case. Court's expected to start up 8:45 a.m. Eastern. This judge is incredibly prompt, runs a tight ship, and as soon as they're ready to go, we're going to take you in there live. So let's talk about what we can expect. The defense rested after Donna decided she would not take the stand, but really seemed like she was struggling to make that decision.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
So after a sidebar, Donna ultimately came to the decision that she would not take the stand.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
So was Donna's decision not to take the stand the right one? And will she change her mind? Let's bring in our legal eagles. So happy to have on the show this morning, Michael J. Brown and John Phillips. Good morning to you both. All right, so let's tackle these questions in turn. First, the decision not to testify. Is it a good decision? Michael J. Brown, what do you say?
Good morning, John. Good morning, Julie. I'll give you the answer on Monday morning because we don't know until we get a verdict from the jury. You know, it's all 20/20 hindsight. Two things I love. I love this judge, and I loved your opening statement. You were spot on, Julie. You know, it's the most difficult decision that we as trial attorneys face. And the clients always look to us for our advice and our counsel and really follow what we suggest. She was struggling. I think that was a genuine struggle for her as to whether or not she was going to testify. But, you know, we've talked about the pitfalls of testifying. The defense attorneys do their thing. They cross-examine. They do the best they can. And in one swoop moment, you know, the defendant on the stand can have all that unraveled by something she says. So I think, and we'll get into this in a bit maybe, I think they got out everything they wanted without having her subjected to cross-examination.
Great points, Michael. John, your thoughts on her decision not to testify. Was it a good one?
I agree. Get ready for this, okay? I am not calling Donna Adelson an ogre, okay, under no circumstances. But as Shrek once told us, ogres have layers, onions have layers. This cross-examination would have a lot of layers, fleeing the country, all of the questions that she'd have to answer. I think she did a great job in the fact that she preserved a possible appellate issue right there in Tallahassee, Florida Supreme Court, DCAs. You know, did I waive? Did I not waive? Did he ask me this morning whether I waive? You know, but the judge has been good. He's got it pinned down. He's entitled to find, you know, the right schedule. But this cross-examination would have so many layers that even Shrek would be humbled.
Oh, John, we appreciate the words of wisdom from you and Shrek. So let's tackle the other questions. So it's possible she could change her mind. So let's walk through what may happen. Let's just say hypothetically, and we don't know here at Court TV, but just based on the way she vacillated, I know I'm thinking I would not be surprised if she comes into court this morning and her defense attorney has to ask permission to reopen their case. Michael J. Brown, what do you think? If she decides that she wants to testify, how do you see this playing out?
Yeah, it's a fundamental right, Julie, even though she waived it and the judge did the inquiry. If she decided before they went to closing arguments that she wants to exercise her right to testify and present her testimony, any judge is going to let her have that opportunity because it's a fundamental right. Yeah, she could do it. I don't think she would. I think she is set. I don't think it would be a calculated thing where they had this all along and they're trying to throw the prosecution off. I think it was something, she was sitting in a jail cell last night and probably struggled with this and probably didn't get sleep and thought about it back and forth. So is it possible? Yes. Is it likely? I don't think so, because I think this was a game decision made by the attorneys along with her, and they were firm and committed to not testifying at the end of the day.
Michael, thanks. John, tell us, what do you think? What do you think? Should she change her mind tomorrow, or does she change her mind today, rather?
I don't. I do think the judge should probably ask and make sure that she's sticking with her non-story. The Fifth Amendment, important Bill of Rights, right against self-incrimination. I think she made the right call. I think her lawyers were probably pushing her in that direction, but as the mastermind, as the matriarch, I think she wanted to tell her story, but realize that there's a lot of twists and turns within that story.
Sure. No, exactly. So let's look at one of these moments where we could tell she was struggling. And even though she's had time, her defense team was saying they didn't have enough time to make this decision.
What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client, so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Michael J. Brown, what'd you think of that moment?
Yeah, I love this judge. I go back to what I said earlier. He is so professional, Julie, but this is not something that they're struggling in terms of the defense. They know as they went along, did we accomplish what we want to accomplish? And they'll know if they think they're going to benefit from putting her on the stand. It's really not, from the defense standpoint, from the attorney standpoint, something that you're going to decide at the very last moment. They knew going into that day. They probably knew 2 days before that they wanted or did not want her to testify. But the client ultimately makes that decision, and she may very well have given them that ambivalent feeling. So that's maybe what they're putting on the record.
Yes, I think you're right, Michael. John Phillips, what do you think? Do you think that the attorneys are advising her, look, let us handle this, don't do it, too much to lose here, we got this one, and that it's her that has the inclination to want to talk?
I think that's exactly it, Julie. I think your gut instinct is dead on as usual. And I also think that there is some gamesmanship by the attorneys to see what the judge is going to do as to whether they could possibly set up an issue for appeal here by forcing the Fifth Amendment issue, forcing the testimony to happen now. I think the judge has ruled exactly as Florida case law holds, but that's not going to stop an application for an appeal.
Right, and bingo was his name. Oh, John, I think you're spot on there that the way the attorney was wording that, I'm sure you both thought the same. Oh, she's really just, this is the groundwork, right? And you could see it being typed by the stenographer. She was saying it, that we need this time to go over all the evidence, making that plea. And as Michael said, come on, they know what the evidence is. They've been down this road many times. This is to protect the record, as you noted, John. All right, so let's show everybody one of these moments in court. This was a Mama Donna outburst moment. Here we go.
She also had a phone call with her son, who's obviously in jail here. 25-minute phone call. I personally listened to it. She very clearly spoke about a plan to kill herself using sleeping pills.
One moment, Ms. Adelson, please keep your comments to yourself. Let your lawyer argue on your behalf.
Okay, so that was at a pretrial hearing. In terms of how Mama Donna does on the stand, some of us in our newsroom were talking about that clip. That's why we resurrected it this morning. Like, oh, is she going to have a tough time if she does change her mind and if she does want to get up there? Michael, what do you say?
They did what they did perfectly. They dressed her down. They made her very grandmotherly-like, and that's very in contrast to how she appeared prior to being arrested. So I think they're going to accomplish their objectives, again, without putting her on the stand. They got out with some witnesses about why she had a one-way ticket, so they killed that issue, at least from their standpoint. They also talked about the fact that she loved her son-in-law and she wasn't that hostile towards him. So they really got out what they could have and did without putting her on the stand, subject to cross-examination. So that's a good move.
Yeah, sure is. We'll see what happens in just a short time. Sometimes we get a court signal at this time. We don't have one yet, but I'll let everybody know when we get it. Our cameras are ready to rock and roll. As our wonderful legal analyst guests, John Phillips, Michael J. Brown, stand by for more cues, please. We're going to hit a break. Friends at home, if you want to get some more coffee, good time to do that. We're back.